Montes, Carrera, D11453, 527. Counselor, your name and bar number.
Good morning, Your Honor. Brandon McCoy, appearing on behalf of Claudia Montez, bar number 10402, appearing unbundled.
John Jones, bar number 6699, appearing on behalf of the defendant, is present.
Okay, it's your motion. I don't know what you want, so explain to me what you want.
Well, you know, the hardest part about this case, Judge, is the position that Dad has been put in by Mom's actions. You've already, I don't know if you had the time to go back and look at
I don't have to. I know this case.
the tortured history of this case. You've now
On
had
both sides many times.
2 false allegations to CPS, unsubstantiated. You have a long history of things that resulted in you warning Mom, hey, listen, if you don't stop this, you know, your designation of primary is in jeopardy. Okay. We have to deal in realities here, unfortunately. And the problem for Dad is she has done so much damage by preventing the contact, by violating the court order regarding visitation, by refusing to follow the court order regarding our family wizard, by basically ignoring virtually everything you expected would bring some normalcy to this case. She has now done so much damage that Dad's biggest concern is, okay, I know I'm absolutely entitled to unsupervised visits. I know I have a court order saying it, regardless of whether she honors the court order. But now I'm worried about my freedom. I'm worried about the fact that if I take unsupervised visits with my son, prior to having him treated and assessed by a psychologist, which you ordered 2 years ago, then I'm running the risk of her having brainwashed him and him making a report that could then put him in jeopardy with regard to charges. It's sad that he has to be put in that position. I came in here ready to basically just say, you know what, Judge, he should have this weekend, and he should have every weekend from now on as makeup time, unsupervised, period, end of story, because there is no basis for there to be supervision. His concern is that if he doesn't get to, A, reestablish the relationship to some
There's no
degree.
supervised visits now ordered, is there?
No, unsupervised is the current order.
Okay.
2 weekends a month, Friday to Sunday evening, unsupervised is the current order. And, you know, we were here, well, we weren't, I wasn't here, I don't believe counsel for the plaintiff was here. Earlier this year, we had day 1 of trial in January, and we came back, and then everybody came back and you conducted a settlement conference, which then resulted in a proposed order that didn't reflect anything that was agreed to. And so where we stand as far as the law of the case is concerned is we're ready for day 2 of the evidentiary hearing. Because if you recall at day 1, Mom perjured herself and it was proven. I mean, it was very favorable to Dad day 1. But he wanted to try to work things out. The problem is ever since then, and beginning at the end of May, he's been cut off from contact. Now, when we say cut off from contact, and this is the real problem with the case. I'm going to read a quote from Mom's opposition. There is nothing that requires her to confirm that she will be abiding by the court order. And then later it says, Claudia does not believe, and Tarzo should not be so significantly inconvenienced to travel to California for 4 hours of supervision. Basically, it's as if Mom doesn't understand that as the primary custodial parent, you absolutely have a higher burden. It's your job to bend over backwards and to go above and beyond to ensure that the relationship between Dad and the child not only exists, but that it grows. She's done just the opposite of what Your Honor expects of a primary custodial parent. So from the standpoint of the order to show cause, obviously that would require an evidentiary hearing anyway, to prove the contempt, to prove that when he says, please confirm you'll be there because you weren't there last time, and she won't even respond, she's required to respond on our family wizard. So we have those issues that will be easily proven. And she can say, well, I didn't read that until 2 days later. Well, you know what? You have a burden when you're the primary parent to actually pay attention to those communications from Dad. And then the court can adjudicate that issue. But we can do that at day 2 of the evidentiary hearing that started in January. We already have the record. We have the transcript. You can review everything that went down. And then we can go into the current situation and Mom's basis for why she does what she does, and how that makes her completely unfit to be the primary custodial parent. You know, when you deal in cases of alienation, and you deal in cases of a pervasive pattern of interference with a relationship, you necessarily have to then immerse the child with the non-custodial parent going forward in a equal or primary custodial level so that the alienation can be undone. The problem is dad is very, very concerned that mom's false allegations, round number 3 this time, could result in some type of charge that could affect his life, not just his relationship with his child, which would also affect his relationship with his child. So from the standpoint of what do we do right now versus what do we do as a final custodial order from this court, I think we scheduled day 2 of the evidentiary hearing that never got completed, so that the issues presented in that motion, as well as the issues presented in this motion, can be decided by this court. And in the meantime, we, at mom's 100% cost, because that was actually the original order, get the child into therapy with a qualified therapist. Now, dad's done some research on this issue of fabricated memories and the type of alienation that leads to false charges actually being borne out as, holy cow, I'm now in jail, or I'm now a child abuser because of something that was completely fabricated. And from our court-appointed list, we believe that Mark Chambers has the certification. My guess is Dr. Linkite, Dr. Polini, Dr. Holland probably do as well as far as that issue, but we do know that Mark Chambers does. So what we would like this court to order is that immediately, and on a weekly, bi-weekly, obviously the therapist is going to decide how it progresses, begin the child in therapy at mom's cost, because mom's the one who's created all this, and it's consistent with the court's prior order that it be at mom's cost. Dad obviously involved in therapy. The therapist getting copies of the pleadings, copies of the transcript, copies of the unsubstantiated CPS records, and that therapy beginning to a point where the therapist then says, okay, Dad, you're actually safe from these fabricated memories, these fabricated allegations, and you can have unsupervised visits. In the meantime, and by my timeline, that takes 90 days. We get things started next week, the week after. 90 days down the road, you're probably in a position that Dad would feel comfortable, given that Mark Chambers has now created, a therapeutic setting, told the child it's okay to love your dad, made sure that there aren't these fabricated memories, made sure that he understands that what mom says and does likely isn't necessarily true, so that Dad is then protected from this issue. In my opinion, there is a sufficient record in this file that if another false allegation was made, he would have no risk of losing liberty or criminal charges or anything of the nature. That's just based upon 22 years of doing this and dealing with the type of nonsense and game playing you're getting from the plaintiff. But I'm not the one whose life is at risk, whose liberty is at risk. He is, and so I respect his concern that he wants to have the contact with his son, and driving to Barstow for 2 hours to have a 2-hour supervised visit on Saturday, and driving to Barstow again on Sunday for a 2-hour supervised visit, while inconvenient for mom, sorry, she's created this mess, and now she has to be inconvenienced. Even though a normal primary parent would say, yes, I'll do whatever I can to make sure I maintain this relationship with my son, that's not who you're dealing with. So that's why the orders need to be absolute, they need to be concrete, they need to be such that he doesn't have to try to confirm in advance that she's going to be there. Because she's already proven she won't show up, and for him, driving 4 hours at that time was a problem when you show up to see your child and mom's not there, child's not there. So we can put the supervised visits in place in Barstow, right? I wanted to make sure I picked the right midpoint city for the next 60 to 90 days, or until Mark Chambers says, you know what, I've got this down, I've treated the child, I've got a report for the court about, these issues. And what I would probably like to do is give Mark Chambers a copy of the video of this hearing as well, so he understands, what was presented to the court and what the court, what the court's thoughts in this regard are. And then be in a position to just immediately upon Dr. Chambers' report say, okay, now we're going back to the every other weekend with Dad. We can worry about make-up visitation by giving him the entirety of the summer rather than the block of time I think that's previously been ordered. There's ways we can fix that problem. But what we need to do now is to order her to come to Barstow Saturdays and Sundays every other weekend for 2 hours, and order the Dr. Chambers treatment and or evaluation so that the court has an idea of what's going on, and so that Dad can actually hang his hat on a professional with the necessary credentials and experiences opinion about what's going on with this child, and that he's not going to be falsely accused again. If we get those two things in place and we set the evidentiary hearing out for a period of time, maybe it's possible that this day two of the evidentiary hearing isn't necessary, but there are still residual issues from the initial motion. There's financial issues involved, there's contempt issues, there's perjury issues, there's a lot of issues. And Dad has had to incur significant fees simply to get what it's her burden to give him, a normal relationship with his child. You gave her the awesome power of being the primary custodial parent, and she's abused that power. So now it's time for there to be actual consequences to that type of abuse, to that type of false allegation, the type of thing you've already warned her against. There has to be a consequence, and that consequence is she's responsible for 100% of the therapy. I'd be happy to submit an affidavit of fees and costs under Brunzell and have you award some measure of fees as an interim relief, with the remainder of the fees being pending the final outcome of the case at the end of day 2 of the trial, or if there happens to be the possibility of a resolution, I think there might be a better chance of that occurring once we get the Chambers report done. But it needs to start right away. There needs to be a concrete time, Monday, Wednesday, Friday at 3 o'clock, that Dad can, I'm just picking that as an example, that Dad can Skype with the child or FaceTime with the child. Meaning, it needs to be clear. Mom has to be with the child in a Wi-Fi place, unless she's got 4G phone, but a place that has Wi-Fi so that the connection can take place so that Dad can communicate with the child and that Mom has to not interfere with that communication. There needs to be, sadly, the most detailed order possible, which I'd be happy to draft and propose to the court, but there needs to be a set time that Mom can't interfere with, and that she knows in advance, one more interference, and I will change custody, because that's kind of what you said before. So,
That's why I'm surprised with your motion.
well, Judge, here's the problem.
Never mind, just keep going.
And I appreciate that. And Dad, and this is where I don't often say that my
I'm tired of saying one more chance.
and I agree with you. But here's the difficulty. And I don't come in and praise my clients very often and say, wow, this is really an extraordinary person. I'm usually telling the court that I'm extraordinary. In this case, he's extraordinary because he could be in here saying, you know what, Judge? The child starts primary custody with me, with Mom having every other weekend, starting today. He knows that that wouldn't be in the best interest of the child because it's been cut out of the child's life for the last 4 months. He knows that that puts him at harm for the programming that Mom has perpetrated in those 4 months. And so he and I actually had a dispute out in the hallway because I wanted to come in and just say, Judge, this is insane. And he's more worried about his child and the damage Mom has done. So it's a situation where this court has almost unlimited discretion to craft whatever order you believe is in the best interest of the child. Dad will accept whatever order you say, He's not gonna say, well, no, Judge, I'm not gonna abide by your order, particularly if it places the child with him more. But his biggest concern is he can't quantify the damage that mom has done so far. Dr. Chambers can. Dr. Chambers can quantify it, and he can fix it. And then dad can be in a position to say, you know what, the child should be living with me in California.
Why not 5 hours on just Saturday instead of 2 hours on Saturday and Sunday?
You understand.
All the supervised visits facilities, the maximum is 2 hours. I would like it to be from 8 to 8.
Can't you bring your sister or some family
Like
to Barstow?
to Barstow and
A
visit?
family member of yours to supervise.
No, I would like a professional that's licensed to do it, so there'll be no problems, because there's obviously gonna be a problem if that occurs. So somebody that's licensed by the state and could communicate with the court. That's why.
And here's the thing, your idea is a great idea. He's concerned that she will say that sister or girlfriend or mom is complicit in the fabricated abuse. This is the struggle that I think you and I are both having, is that his concerns are very, very real given the history of this case. And he just wants to have this buffer for, as, you know, Mark Chambers could solve the problem in a month, and then we could be back on a status check in 45 days and be in a position to say, okay, we now feel comfortable enough that we don't need supervised visitation, but at least it'll be documented. At least the therapy will have occurred, and he will be protected. I do appreciate the court's.
But going to Barstow and then coming back, and then going back to Barstow the next day, it's a lot of driving for everyone, especially the child who's gonna be doing.
I understand that, Judge. And if you want to say that it's every weekend on Saturday, can you do every weekend on Saturday?
I'll try my best. As a work, I have to take care of my work.
So, I mean,
The other thing is, she takes a child to Barstow on Saturday, and he goes to the supervised visits for 2 hours, keeps the kid overnight, and then does supervised visit another 2 hours on Sunday, and mom picks up the child. I don't know if that helps, because you have 4 hours of supervised visitation with 4 hours of a professional watching. I know we have that overnight that could be subject to dispute.
yeah, I think it's,
Otherwise, it's gonna be 3 Saturdays a month for 5 hours, or 2 hours is the max.
that's what they're saying. Now, here's another possibility.
It's 2 hours at a time. Maybe he can do 2 hours in the morning, 2 hours in the afternoon, I think. I don't know. I don't know what the facility he's talking about.
Well, I guess then what I would ask, because the other thing that I don't know if you've investigated and we might need to, is there a private supervised visitation providers who are certified and who are, you know, on a court-approved list, who could do it for a larger block of time. It's more costly. The question then becomes who shares that cost and at what level. But that can be found, and so what I might suggest to the court then is that you could set it for 2 hours on Saturday, 3 weekends a month, unless he can obtain a private supervisor, and then it can be as many hours in a given Saturday as he would like to have, 3 weekends a month. And that would be during this time of Chambers' assessment of the situation. And that would probably be doable as an alternative. The only reason I get concerned, and believe me, I can craft the order as clearly as possible, and I do believe to some degree that plaintiff's counsel will try to rein things in a little bit with her. And frankly, I don't know what the argument's going to be by them, and frankly, I welcome her standing up and saying it's inconvenient for me, because that just plays into exactly what my analysis of the case is. But I think if we craft in the alternative, at a minimum, he has 2 hours every Saturday at this facility in Barstow for 3 weekends a month. If he's able to arrange for a private supervisor who is certified, that it can be as many hours on a Saturday as that supervisor can do it, and mom will share equally or pay 75% of the costs thereof. And hopefully we only have to worry about that scenario for 60 to 90 days. We get Chambers involved, and we see what he can report to the court, and then we're in here arguing for the type of order that I think you're inclined to grant already.
Okay, your turn. While you're talking to your client, find out when he would like to have Skype.
Your Honor, with respect to why we're here today, this is based on my client not showing up for visitations. He alleges that she wasn't there, that he drove to Barstow. That's just not the case. She drove to Barstow in June, waited for the defendant to show up. He didn't show up. She purchased a receipt to show that she was there. She has a witness here that went with her that can testify that he wasn't there in June. She went back in July for their...
Well, number one, your witness is my friend.
I'm not aware of that. So
Well, I just let you know and let him know.
fair enough. So, nevertheless, she was with her. She
You
went.
have the receipt so you can give it to counsel?
Those receipts were with our exhibits. They should have been filed with.
He has them already?
Yeah.
I don't see exhibits to the opposition, but
Can you look at his plaintiff's opposition and see if there's like exhibits of receipts and print them out?
So, but that was in June. There was also July. She went back in July for the first visit. He didn't show up for that visit either.
You have receipts for that one?
Yes, we have a receipt for that one. Again, that should be with the exhibits. Then she went back a third time, Your Honor, and he didn't show up a third time. And she has a receipt for that. And again, her witness was with her. Then he claims that the times that he had FaceTimed, that she wasn't available or didn't respond. In his own exhibits, and we pointed out in our opposition the specific dates. For example, he claims, and he doesn't provide any specific dates, he just simply says Claudia's non-compliance of FaceTime order is lacking in specificity because he just simply says, I FaceTime him and there's no response. But if you look at his actual exhibits, he lists off every Tuesday and Thursday from July 14th through August 11th. Those are the days that he allegedly FaceTimed and she didn't respond. It's inaccurate based on his own exhibits. There's a response from my client, Claudia, June 17th, 2015, on Our Family Wizard that Marvin is not making the calls on time, and while she typically accommodates him anyway, sometimes there are other things going on. She can't do that at the same time. She responded to him and said, look, you've called after hours. You've called after you're supposed to call. She's obviously not supposed to just wait around for him to call. If he's calling late, that would certainly come out in an evidentiary hearing. It's going to be clear from his FaceTime log exactly when he called, if he called at all. But the bottom line is she responded through the Family Wizard saying, hey, look, you didn't call on time. What am I supposed to do? Let me know when you're going to call. That was June 17th. Another one of his exhibits reflects on June 23rd, 2015, after an unsuccessful round of phone tag, Claudia advised Marvin the following day that he could make up the time. Again, she's not doing anything to keep the child away from him. It's the defendant. He's not showing up for visits. He's alleging that he's FaceTiming her when either it's very late after his scheduled time or not at all. But again, he wants to blame the mom. And then July 16th on Our Family Wizard, my client's response to the same allegation that he had called and she was non-responsive, there's call logs, witnesses to Marvin speaking to Tarzo on FaceTime on July 14th, August 4th, and August 6th. And these are just some of the things that were in his own exhibits where he's actually talked to Tarzo, or my client has responded and said, hey, by the way, you called after your scheduled time. So she's not withholding the child. She took him to Barstow. He didn't show up. Now he's saying, I want supervised visits, and I want you to come to California, and we're going to do 2 hours of supervised visits there. In response to counsel's out of context response or statement, he says, Claudia does not believe that she and Tarzo should be so significantly inconvenienced to travel out of state for 4 hours, making it seem like my client doesn't want to follow court orders or do anything. That's in response to their supervised visits and his client's request that my client have to pay for the extra travel, the extra distance, and the supervised visits. Her response is simply, look, if you look at the full paragraph in its entirety, if he wishes to have visitation limited to 4 hours per month and supervised, then he should be responsible for it. My client shouldn't be inconvenienced. She shouldn't have to travel the extra distance. Again, if they want to have the supervised visits, that's fine. My client would suggest we do it here in Las Vegas. They can do the 4 hours. My suggestion would be Dr. Chambers can do that evaluation, and if he offers the service, then have him do not only the evaluation, but he can provide the supervised visitation at the same time, if he does that.
Who's
But
that?
Dr. Chambers, Tom Chambers, I believe is his first name.
Mark.
Or Mark. excuse
Tom
me.
Chambers is a basketball player.
Yes, that's
What
right.
we-
But that's just one of the...
Chambers is probably gonna work Monday through Friday.
Right. And he's not going to do supervision, particularly at a PhD level.
Let me finish. I'm just suggesting if he offers that service, then he can have the evaluation as well as the supervised visits. My client's witness has offered to do the supervised visit. Doesn't sound like that's an option, but that's certainly a good suggestion. Someone other than a professional, but again, that's something that the defendant is wanting. And again, he's saying he needs to have that because my client's going to make allegations, false allegations, the like. I will say that there's an open investigation in California
When did you start on this case?
2 months ago, whenever we filed our opposition. I understand. I
I
know
thought
that.
you might have been here earlier.
No. I know that there's a long storied history. The bottom line is
It's been like pulling teeth from day one. And if you read the record, I went super slow. Whatever mom wanted, she got.
and I don't know what the court's concern is. Then if
But
the
it
court's saying
never resolved the problem.
she's, and you'll see in our opposition, we put in our opposition as far as
We get going with visitation. Child's getting sexually abused now. Oh, maybe I was wrong, or maybe I was over concerned, and maybe the child didn't really mean that. And we get going again, some other allegations come up.
these allegations.
Can't even
as
get
far as-
through 6 months without some problems coming up from mom.
Again, I can't speak to that, but with respect, I'm just
Just
letting.
trying to inform you because you were
That's-
not here.
That's fine. But all I'm advising, and I know
It's in
that
that transcript there.
I know that there's history there. There was those allegations, CPS unsubstantiated. The bottom line is, she's complied with the orders. She has gone to Barstow. He didn't show up, and now he's blaming her for it. If you want supervised visits, that's fine. We'll grant the supervised visits. Now it's the logistics of it. Is it going to be done in Barstow? But this is something that the defendant is requesting, but then he wants the plaintiff to pay for it, alleging that she's not following the order.
Now, the supervised visits, if he wants them, he'll pay for them.
Fair enough. The other option,
The other expert, you guys are gonna have to share until we get a confirmation on what's going on, and then we'll
That's-
retax it.
that's fine. The other thing, Your Honor, is the defendant was ordered to do the UNLV classes, the co-parenting through, and I don't know that was done. And again, if defendant were to complete those, maybe that would resolve some of these issues. But he's got to understand that if he's not calling at the required time and the plaintiff isn't there, that he can't get upset and claim that she's withholding him. If you look at the Family Wizard, she would respond, she's offered makeup time, those types of things. But again, defendant can't simply show up for visits and then blame mom for not being there or withholding the child. And that's what's happening. He missed the last 3 visits, Your Honor. And sounds like he's had opportunity after opportunity to spend time with his son, but then doesn't utilize it. And here we are today. So I know we've requested a new trial. We'll leave that in the court's discretion. Based on what the defendant supplied in his own exhibits, clearly shows that mom was responding to him and explaining what was going on. And then also, Your Honor, we've asked for attorney's fees. Again, she was there, he didn't show up. I would like him to provide proof that he was actually there in Barstow. None of that was in his moving papers. There's a lot of history on the case, but there was no receipts that he was in Barstow, and because there aren't any. We've already addressed the child therapy. My client would like that. The other thing, Your Honor, I would point out is that after these 3 missed visits, again, he alleged that it was my client's fault, and then he sends her an email saying, I want to suspend my visitation. So to address that fact that there hasn't been any visitation, it has nothing to do with plaintiff. It's, again, dad is simply going to say, I threw up my arms, I couldn't do anymore. Mom continues to prevent visitation, so I'm just going to suspend him. But that, again, is not what's happening in this case. We've asked for our attorney's fees, Your Honor. We think
I don't have any receipts that she went there.
I know that they were provided to my office.
Well,
so I will.
That's where they are probably at, because they were not filed.
Then I will have those filed. I know that
Yeah, 'cause they're
she
important.
provided receipts, and I will
Make sure the other side gets a copy.
certainly.
Because your opposition has no exhibits.
Yeah, there was receipts that were provided to my office via email. So I will certainly ask my staff, my paralegal that handled it, why those weren't included. But we will supplement it. But again, we do have her witness that says that she was there on those 3 visits and he didn't show up. And how long did you wait for him?
For quite a bit. We waited for like 30 minutes.
And did you call him?
We sent an email saying, I verify the visitation. I'm going to be there. Even though we have a court order, I still send them a verification because he asked for one. So I did. And
Okay.
he still didn't show up.
Okay, so I'm going to grant the supervised visits in Barstow. You need, like you said, to prepare an airtight order, so you'll prepare the order. It'll be every other weekend. It'll be for 4 hours. The first two have to be supervised. Number one, this will confirm that everyone's there on time. And then the other 2, if he cannot find a private supervisor, or if he wants to use the other 2, he can do it without supervision or with a private supervisor, or not do it at all. But there'll be 4 hours on Saturday. It'll be every other Saturday. So we'll get to the bottom of who's there and who's not there. Now, if your client's not there, then,
Judge,
there's gonna be a lot of fees to pay.
he actually has receipts from when he went. And the question I have is simple this.
Well, I want you 2 attorneys to compare your receipts.
Yeah,
and
definitely,
figure-
'cause
and
we haven't
figure
received a
out
copy.
What happened those times?
But here's the part that's so amazing is you see her responses about FaceTime on our family wizard, okay? You see 0 responses from her when he says, please confirm you will be there so I don't make this trip and have you not be there like you weren't this time and the other time. Not a single response. So we know she knows how to use the wizard because when it's about FaceTime, she can respond. Oh, you didn't call on time. You didn't call on time, and even though I'm the primary parent, that means that you don't get to talk to him. I mean, that's the heart of the problem. But she responds regarding FaceTime, but when he simply asks, please don't make me drive there and have you not be there, crickets chirping. The absence of a response to his requests tells you everything you need to know when you've got responses regarding FaceTime.
Well, they were both supposed to get receipts, so the time she was there and he was not there, provide them the receipts. The time he went there and she was not there, provide them the receipts, and you guys figure out what's going on and who's playing games. But The first 2 hours from now on will be supervised at dad's expense. He can supervise more with relatives after that, or not use the time, or get a private supervisor. Chambers will be used for therapy, starting right away with the child and dad and mom as the therapist sees fit. And the records and reports will be released to both sides and to the court. So what time are we gonna have FaceTime or Skype, or what are we talking about?
Tuesday and Thursday, 3:30. And here's what I'm gonna suggest. Since she's saying he's not doing it on time, she places the FaceTime or the Skype at 3:30 to him on Tuesdays and Thursdays. He will be waiting. And even if he has other things to do, he knows as we walk out of here today that if he's in China, he's going to have to find a place where he can FaceTime or Skype. At least on my instruction.
So, is there a difference between Skype? Which ones are we using?
FaceTime is on a
FaceTime, we have
iPhone.
FaceTime.
Skype is a computer.
We have FaceTime.
Oh, it's
Or,
FaceTime.
or a tablet, but
That's what we've been
FaceTime.
using.
He has a phone.
FaceTime is
so-
what he's using.
FaceTime.
Mom has a phone.
So she'll call at 3:30 on Tuesdays and Thursdays?
If I can confirm, because it was Tuesdays and Thursdays at 12:30. That's when he was supposed to call.
3:30.
So,
3:30. Thursday gets off of school at 12:30.
okay.
What was this?
I just need to, because originally it was at 12:30, Tuesdays and Thursdays. I'm just making sure that 3:30 works.
Just give me a time that works for her.
So-
I can commit to one once a week because I have to be at work. I mean,
What time works for you?
3:30.
I'm at work at that
What
time.
time? You work 24 hours?
I get off at 6. I get home by 6:30.
Okay, can you do it at 7?
Yes.
He's
Do
working.
it at 7?
He's working then.
I'll be available. I'll answer the phone somehow.
He'll find a way.
Find a way.
7 o'clock?
7 o'clock.
Yeah, I mean, the child's 4.5. It's not like it's going to be a half hour
So
long.
call at 7 o'clock. There should be a record on your phone that you call, and there should be a record on your phone that she called. 7 o'clock Tuesday and Thursday. Is that a good time for you?
Yeah, is that, he's
Yes.
asking.
Yes.
The chamber's expenses will be divided 50-50.
And can we have a specific order?
You're gonna draft it, so you,
No,
what do you want in
I
your
know,
order?
but in addition, because my client reminded me, that mom is not to take the child to another therapist. Mom is to also make sure dad's aware of any medical treatment, things like that. But mom's already tried to take the child to a therapist in violation of local rule, things like that, twice. So that she needs to be told, don't do it, period.
That's fine, Your Honor. It's not true what they're saying, but she will advise him of.
She didn't try to take him to Red Rock Counseling?
Your Honor,
I had
we're
asked.
regressing at this point. She will take him to
Put
the
it in
therapist.
the order, no other therapist to be used without permission of the court. If any other therapist is used by anyone, counselor, if any other therapist is used by anyone, it will not be accepted by the court in any fashion, their
And
report.
can we order both parties to check Family Wizard every day?
They're supposed to do that.
My client,
I know
my
they're supposed
client
to do that.
does. I mean, that's
Okay,
fine.
then respond within 24 hours.
She is responding. That's again, if we want that order,
So-
she'll
So it's
respond.
okay to put it in the order, right?
Fine. I mean,
And you know what?
really,
I'll be happy
we
to
gotta
send.
micromanage it to
No,
that
I'll
point.
be happy to send counsel every Family Wizard post my client has made, and he can show me a corresponding post. How's that?
I'll have
It's not
I'll have my law clerk check every day for
That's
the next 90 days, so put that in the order that the law, excluding Saturday and Sunday. Because I'm not gonna make my law clerk work on Saturday and Sunday.
And a response within 24 hours.
How old is this child
Here's the
now?
thing is,
How
you're-
old is this child now?
he's 4.5, Your Honor.
Okay. And this case started,
2011.
2012, Your Honor.
okay, so we're 3 years, and you know, like we're like at step one again.
And Your Honor, I would point out, the parties have been doing this exchange in Barstow for 3 years, and now he's claiming that somehow he needs confirmation that she'll be there.
Well, we're gonna
She's
have.
never missed.
We're gonna have confirmation, and he's gonna pay for it.
Fine, he'll provide us the receipts.
For the counselors, the supervisor.
I would like to see
I-
his FaceTime logs too of all the times that he called and
Listen,
exactly what time.
She can show you.
I'm happy to have discovery open,
No,
Judge.
because he's claiming he's called my client and she hasn't answered or responded. I would like to see his FaceTime
Okay,
log that
well, then you
shows
want
that.
discovery open like he
Yeah.
wants? Okay,
Yeah.
it'll be open. You need to tell us who the supervisor is before we have our first exchange in Barstow.
For the facility in Barstow.
Yes, it's a desert, we have it in our motion.
Yeah.
Well, that was in Los Angeles.
Yeah, that one was.
No.
It was not in Barstow.
In the reply.
On the reply. No, it's on a motion. Let's see, where's our motion at?
Well, page 10 of their motion was Kids First of Los Angeles County. That was the proposed one. It wasn't Barstow that was contemplated.
Kids first.
I see
In
Desert
addition, question
Sanctuary
from
is on
the
page
supervisor
10,
given-
page
No,
10, line
Desert.
18.
Okay,
Oh, there we go,
There
yeah.
you go, Desert.
Yep.
Desert Sanctuary.
703 East Main Street.
So we know where it is.
I thought it was a funeral home.
Sadly, no.
Desert Sanctuary?
Desert Sanctuary and
I don't think I would want to go there, but okay.
and Your Honor,
You'll need to
Whatever
find out what
the
time.
let's,
facility
if we can,
decides,
so we
it's
can be
okay.
specific, again, it be understood, my client will continue to purchase a receipt. If he's not there within a half hour, she doesn't have to stick
She
around.
just goes
Unless,
in there, she
Huh?
just goes into the Desert Sanctuary and gets something from the receptionist.
right, but I just want it clear so that, again, he's late or says, hey, I'm running an hour too late, can you stick around? She's not obligated to stick around.
Half
So,
hour only.
fair enough.
One other
You get that
request.
half hour? If he's not there on
Half
time?
hour, sure. And he'll notify her as soon
Oh,
as he knows.
when is this gonna be ready?
We,
Desert Sanctuary, you know, I don't
He'll
know.
call and schedule for
Are they gonna be
next-
open on Saturdays?
Yeah, it's open on Saturdays and Sundays, but they decide the time. All I could do is request, or she could request. It's not in our
You
hands.
call,
up to
you
them.
call today.
Well, we gotta have
and get
a time.
Well, he'll just have, what we'll say is that he will give her notice of the time of the appointment 48 hours in advance. Meaning, family wizard her, the appointment's at 2 o'clock on Saturday, the appointment's at noon on Saturday, the appointment's at 10 on Saturday. And he won't do it earlier than 10 because that gives her the 2 hours to get there.
Well, I want the first appointment to go from attorney to attorney.
And that's fine. We will do that.
and if we could set it at a specific time, I think.
Well, I think.
Well, he may not be able to, and if they'll let him book it in advance,
I understand.
Yeah,
We'll do that.
I want it to be booked in advance if possible, so we'll have the same time
It
every
would help if
Saturday.
it's consistent, yes.
I have one
I
more.
don't want her driving out there at 4 o'clock on Saturday afternoon.
I don't either.
Right.
I don't either. One other request, Judge. He's in town, obviously, for this hearing. He leaves to go back on Saturday. The child does not have school tomorrow. If he can arrange a Donna's house visit tomorrow, can he have a Donna's house visit tomorrow?
I don't know how you can do that. I don't, they're supposed to go through orientation and all that.
Well, they already have. They used to have
But
visits.
we used to, I don't know.
Didn't you have visits at Donna's house already? So they've already done all that. Meaning, if he can arrange it. If he can't arrange it, obviously he's not in trouble. Just, I'd like him to be able to see his son.
That's fine, my client's fine with that, as long as
So when
Donna's
is
house
it,
is able to.
tomorrow or Saturday or Sunday?
Well,
Well, he
this
leaves-
weekend is Halloween, and so while we're on the subject, my suggestion would be that these supervised visits in Barstow occur either next week or as soon as he's able to arrange it,
gonna
but
be
not, but
this
not
It's not
this
gonna be
weekend.
this weekend.
Just so it's clear.
The first weekend will be
Yeah.
next weekend.
At the earliest.
And if he can arrange at Donna's house today, or for tomorrow,
Yeah, my client will,
Well, tomorrow's Nevada Day and he's never been there for a while and so.
will Donna's house
but-
even be open tomorrow?
So attorney to
I
attorney.
don't know, we'll have to check.
I don't think it'll be open
Okay,
tomorrow.
you need to set it up, attorney to attorney.
Try.
Are you working tomorrow?
No.
I work every day, Judge.
Okay, so
So
I
yes,
guess
I'll be-
we'll
I'll
have,
be in my
I
office.
guess
I'll give
we
him my
have,
cell
I guess
phone.
we have until 5 o'clock today to get this Donna's house set up, so you can get notice.
Fair enough.
Yeah, he'll try to call them as soon as we leave here. What is your cell phone number, by the way? Mine's on my business card, so.
You're braver than I am.
Thanks.
And I want the record to reflect that both parties have agreed on Chambers. It was suggested by the defendant, but the plaintiff agrees Chambers will be okay.
Okay. Thanks very much for all your time.
And Your Honor, if we can
And
reserve
I
the right
want,
for attorney's fees.
you're both gonna exchange the receipts,
Correct.
but I want both of you guys to put them on a joint letter and send them to the court so I can see them, because I don't have either receipts on either side.
Okay.
Okay, all right, thanks, Your Honor.
Thank you, guys.
Page 1, Your Honor.
Or you should just, you already submitted those.
Oh, yeah.
Any other receipt that you have.